Hello everyone, I am Dr.A.NAGALAXMI, Assistant Professor, Department of Commerce with Finance in Dr. SNS Rajalakshmi College of Arts and Science, Autonomous, Coimbatore. I am happy to share a PPT in the topic Abuse of Dominant Position, Section 4, which comes under Competition Act in the course 21 UCF 801 Corporate Financial Law Principles and Policies. Now we are going to see what is meant by dominant position. A dominant position means a position at the top and has strength in the market. So dominant, it's a general term. Who dominates is called as a dominant. So abuse of dominant position, that is having strength and landing in the top position but abusing their position, that is called as abuse of dominant position. Now we are going to see the prohibition of abuse of dominant position. It means that a group is restricted complete from abusing its dominant position, that is position of strength. A group is said to be in a dominant position when it can operate independently. That means the competition cannot affect its market. It can affect the consumers or its competitors or a relevant market in its own favor. Dominant position of an enterprise itself is not prohibited. However, if the enterprise by virtue of having dominant position in the relevant market abuse its dominant, then the same stands prohibited. Now we are going to see what constitutes abuse of dominance. Dominance refers to a position of strength, as we know it earlier, which enables an enterprise to operate independently or competitive forces or to affect its competitors or consumers or the market in its favor. Abuse of dominant position impedes fair competition between firms, exploits consumers, and make it difficult for the other players to compete with the dominant undertaking on merit. An enterprise or group is said to have abused its dominant position if it directly or indirectly imposing fair conditions or price, predatory pricing, limited production, market or technical development, creating barrier to entry, apply dissimilar conditions to similar transactions, denying market access, and using dominant position in one market to gain advantage in another or relevant market. Now we are going to see the combination and its regulation. It's important to know what is meant by combination. So in the business setting, mergers and acquisitions are critical for growth, efficiency improvement, and market expansion. These company mergers, however, are subject to tight regulatory frameworks to maintain fair competition and prevent market power concentration. Combination under Competition Act 2002. The Competition Act 2002 used the term combinations, which encompasses mergers, acquisitions of shares and assets, and taking control of a business. The fundamental justification for a combination of merger, that is the merger, is that the combined entity value is projected to be larger than the sum of the independent values of the merging commodities. So here what we saw is combinations and its regulations. Now we are going to see what is meant by a combination. The acquisition of one or more enterprises by way of merger or amalgamation or control over enterprises is regarded as combination. A combination is an acquisition of one or more enterprises by one or more persons, merger or amalgamation of enterprises if it meets the prescribed monetary thresholds and involves any acquisition of control, shares, voting rights or assets of any enterprise. Any acquisition of control by a person over an enterprise where such person already has direct or indirect control over another enterprise in a similar business. Any merger or amalgamation of enterprises. So I think we got some idea about abuse of dominant position as we are aware about this topic earlier. Thank you. Thank you so much for your patience listening.